One of the duties that we flew past really quickly during the semester was the duties that lawyers owe to other practitioners. So I just wanted to remind you that we talked about them in week 9. I think they were timetabled originally for week 8. We moved them into the first half of week 9. And it'd be well worth, because of the way we flew through them, just to go back and make sure you've consolidated the reading and that you're happy, that you understand everything that's relevant there. I've had a couple of questions about undertaking, so most of this short video is going to focus on that. But it is worth reminding yourself that there are specific duties that lawyers owe to other members of the profession, and it's worthwhile thinking about why those duties arise. Now, mostly we talk about them in the context of the duties that lawyers owe the other side in a transaction or the other side in a piece of litigation. But there are also duties that are interwoven when lawyers work together. And I've made reference to supervision, for example, in an earlier video. In week 7 or 8, we talked about the ways in which, actually, no, it was in week 8 when we talked about financial matters. We talked about how lawyers will have responsibility to take action if they're put on notice that their partners might be doing something untoward with the trust account, or that they might be otherwise creating issues. So think about the reasons for these duties, and they will clearly come back to the idea that the practice of law is a profession, and that there is an obligation to ensure that practitioners uphold the good name of the profession, and that there are benefits to the administration of justice in people respecting and trusting lawyers. So our behaviour needs to be respectable and respectful and trustworthy. So the duties that we owe to other lawyers encompass concepts of honesty, fairness, courtesy. We need to speak about each other professionally. We need to be honest and accurate in the representations that we make about our case or our transaction, and ultimately we need to adhere to undertakings. So I really wanted to focus in here on undertakings in particular. So an undertaking is effectively a kind of promise, a solemn promise. A failure not to honour that promise, so a failure to honour an undertaking, can be contempt, it could be misconduct, and ultimately a lawyer might be liable to pay costs or be reprimanded by a court in situations where undertakings, particularly undertakings to the court, are not honoured. A failure to implement an undertaking is prima facie misconduct, even if there hasn't been any dishonourable conduct. So this means that lawyers should not give undertakings unless they know that they can keep the undertakings. They should not make promises unless they know that they can fulfill those promises. An undertaking that's given by a partner of a law firm will bind both the partner and the entire firm. One of the key issues that arises is whether or not the undertaking has been given by the firm or the lawyer, or whether it's given on behalf of the client. So it's an undertaking of the client that has been communicated by the law firm. Now, these disputes arise. Think about the reasons why these issues come up, and they arise in large part because mostly the person who the promise has been made to wants somebody with deep pockets to be keeping that promise. The issue of whether a promise that was made or a representation that was made was or was not an undertaking only really arises in practice if and when it's not kept, where the client or the other side, the documents aren't delivered, or the date isn't met, or the client doesn't show up on time, or whatever the subject matter of the promise was. And so often that's the reason that the scramble will be on to point a finger and say, Mr. Lawyer, Miss Lawyer, you made that promise, so you're liable if it wasn't kept. And so clearly, if you are communicating undertakings or promises that your client is making to the other side, it is absolutely key that you are really clear that that is not your promise, that the promise is being made by the client themselves. Take a look at Rule 6 of the Australian Solicitor Conduct Rules. That's where you'll find the codification of the common law, and Pont provides many, many cases, some of which we talked about in the class. The key rule when we're looking at the cases, and remembering back to your contract law days, is what we love to call in Latin the contra preferentum rule. In other words, to the extent that there's any ambiguity in a promise that is made by a lawyer, then that will be construed against the lawyer. So special care needs to be taken when you are wording an undertaking that you're giving to somebody who is not a lawyer. And the case we talked about in the lecture was Coll and Floreat merchant banking. It's dealt with in Pont at around page 766. And essentially in that case, it was held that a court will not strain the interpretation to undermine the nature of the lawyer-client relationship. So again, think about that. Undertakings come out of the relationship that we have with our clients, but they're not expected to create some additional obligation. And Justice Bryson in Russo and Dupree essentially said that an undertaking will not require the solicitor to step in come what may. There needs to be some room for some reasonable range of conduct. And at the end of the day, you don't want undertakings to be addressed by a court. You want to make sure that they're clear and it's clear who is making the promise. Chapter 22 of Pont is probably the best place to look at. And again, think about why. These questions come up, or problem questions will often refer to undertakings, and they'll basically be asking you, most likely, to either identify who gave the undertaking or whether it is an undertaking at all that needs to be enforced. Questions, concerns, frustrations, compliments, you know where to find me. Cheers.